Shari Fleming is an attorney and accredited estate planner focused on helping individuals build and businesses build, protect, and preserve their wealth and legacy. She is a principal of the law office of Shari Fleming, and her areas of legal practice include business organizations, real estate, estate planning, and estate administration. She also serves as a plan giving officer for Bowie State University and is responsible for cultivation, solicitation, and administration of gifts involving estates, trusts, and other gifts that reflect deferred giving opportunities. Shari is a graduate of Lincoln University and the University of Maryland School of Law, and was named one of the Daily Record's 2021 Leadership in Law Generation JD honorees due to her dedication to the practice of law and for advancing the concepts of ownership, wealth maintenance, and wealth retention, specifically within communities of color. Her presentation is titled Estate Planning Basics: The Fundamental Things You Should Know to Properly Plan for Succession and Transfer of Your Estate. Please type any questions into the chat and I will present them at the end of Shari's presentation.
I am so glad to be here with you to provide you all with information regarding organizing your estate. And so again, my name is Shari Fleming. I am a UM Law grad, so it's a pleasure to be amongst company. This slide simply goes through the points that I said I would summarize today, but I have a picture on here of a difficult discussion guide, a guide through difficult discussions. It's a resource that I developed. It's available on my website, sharifleming.com on the bottom, and it gives information about some of the things I'm going to discuss today, but its primary source is to really get families and get individuals who are going to be estate planning, get comfortable with having difficult discussions, first with yourself, then with your family members in your community. And so I have to give my disclaimer here that while I am a licensed attorney here in the state of Maryland, based in Owings Mills, this presentation is not legal advice. It should not constitute legal advice specifically to you, but it is information that you can use and seek out the appropriate services, legal services, to really make sure that this information is tailored to you. And so that is a theme that I really want to leave you with. If I leave you with nothing else, you don't know what you don't know. And so because you don't know what you don't know, you need to take the information that you receive and really seek counsel or guidance to make sure that you're making the best decision for you. Because what will work for your siblings, family, what will work for your friend's family or your friend may not work for you in estate planning. So you really have to know what your goals are. So why do we estate plan? Why do I have this job? Why do I have this practice? Why am I in this? I'm in this career of estate planning because we're in a unique time where we are actually in the middle of it. The largest wealth transfer that we have seen in this country, where the former generations, the silent generation, the baby boomer generation, is transferring significant amount of wealth to future generations, to include Generation X, millennials, Gen Z, and Gen Alpha is the youngest generation that we have now. And I find that if we are not intentional in planning, a lot of unintentional and unintended consequences will happen. And I just feel like a large population of our country isn't paying attention. And so here are some stats. John, I'm so gracious that he went through some of them, but 2 out of 3 Americans do not have a will despite the COVID-19 pandemic, which was catastrophic and devastating on many communities. Despite that experience, people still don't have at least a will. A will is a tool within an estate plan. It is not an estate plan itself, okay? Middle-aged adults, this one is unique. Middle-aged adults, which I turned 40 in 3 months, and my mother made it very clear that I'm probably middle-aged. I'm going into the middle age. So I think we need to also reculture what we consider elderly, middle-aged to be, particularly looking at some of the statistics for mortality, how long people are living now. But middle-aged adults really are not estate planning the way that you would think someone would estate plan as they grow older. But we're finding that young adults who are entering into their careers, that their estate planning has increased drastically. And so young adults 18 to 34 are now estate planning at 27%, whereas Americans 35 to 54, the ones we typically see, 26% for the younger age group, 27% for 35 to 54, that number hasn't really changed over the course of time. And so I like to do these presentations because I want everyone to know that they should be making some considerations. So 1 in 3 Americans, if they don't have a will, they claim they don't have enough assets to leave behind. And I found a recent study very interesting in that when it asks individuals, what amount of money do you think you need to make in order to be financially secure? And what amount of money do you believe you need to make in order to be financially free? And you can see from the slide, $233,000 a year and $483,000 a year, respectively. But the average household income of an American family is around $57,000 a year. And so a lot of estate planning, I find that I have to really educate and teach and really get you to think about your relationship with wealth, your relationship with your family members. So when we are discussing what do I need to organize my estate, I think you need to think about what is your relationship with wealth. What is enough for you? What does financial security look like for you? What does financial freedom look like for you? And the reason why I want you to think about that is because that will determine what you do with it. If you don't believe you have enough, whatever enough is, to transfer, then those individuals typically are less inclined to actually estate plan. Again, I give a lot of statistics because I want to debunk a lot of kind of things that just aren't true. And so some people think individuals who are highly educated estate plan. The data shows that individuals with postgraduate degrees actually are decreasing in the rate that they estate plan. So the issue of estate planning and the issue of individuals not planning, and we'll talk about the consequences of not planning, it really affects middle America like myself. It really, and there is no real educational difference. So it doesn't matter if you don't have a college degree, have a college degree, have postgraduate degrees, the numbers are really the same as to why the number of people who are estate planning. So another thing that I noticed is that a vast majority of individuals are not using professional advisors, regardless of income level. I'm not sure why this is occurring, but again, you don't know what you don't know. And so I hope that from this session, one takeaway when we're talking about organizing your estate plan is that you at least have one trusted advisor. The industry that advisor may be in, I don't care, it could be an industry, any industry. You could have a lawyer, you could have a financial planner, you could have a CPA, but that you have, you could have a philanthropic officer, but you have someone that you're in a relationship of trust with who is actively related or working in the industry of estate planning, so that they can highlight some red flags for you that you may not see that will cause you to plan. And again, you'll learn in a later session today the different things that the different ways your estate plan should change over time. And John mentioned this, procrastination is our individuals' view of their wealth as are two real big barriers to estate planning. And we now have some data to support that. So Estate planning isn't for the rich and the famous. Estate planning is more about protecting your assets. We'll talk about legacy. Legacy is more than just money and finance. Estate planning is a component of legacy planning. Estate planning involves your desire to be remembered even after you've lived a long and fulfilled life. And so when I talk about organizing your estate, the one thing that I want to encourage you to do is to really think about your current life. What do you do? Why do you do it? Where do you work? Why do you work there? Who's your community? Who do you have? What do you have? Who do you have? Your family, your community. Think about those things. Think about the life that you are living, the life that you are enjoying or hopefully enjoying, and think about what you want to leave here. If you are someone who is responsible for people like myself, I have 3 daughters, 2 of which are teenagers. One is 6. We tried for a boy, but she came out a girl. But they're not the only people I'm responsible for. I'm responsible for parents. I'm dead smack in a sandwich generation where we're caring for parents and children. And so should something happen to my husband and I today, we know that someone has to kind of take our place and being caregiver to our parents who need support and to our children who still need to matriculate through life. And so our plan, and that being our primary goal, really, our plan is centered around making sure that that happens. What is needed to replace he or I should something happen to either one or both of us? And it is one of the heaviest lifts because you find that when really thinking about situations, that financing your life and financing the support that you will provide your loved ones or even the communities that you support. I am a part of Delta Sigma Theta Sorority Incorporated, which is a national Panhellenic organization. It is a Black sorority where we are invested in scholarship and community service. And so that's a part of my legacy. There is something I'm going to leave to that organization. There is something I'm going to leave to my college, which is the first historically Black college and university. There is something that I'm going to lead to my law school, which developed the professional in me. So when I think about what I do with these institutions now, in addition to my family, I have to also think about, if I leave, what kind of void is left with those institutions? And so my estate planning encompasses all of that. Okay, so let's discuss some estate planning tools. I use the term tools intentionally. Okay, they are tools in the toolbox. Okay, we are building a house. This is the scenario I like to give my clients with estate planning. We're building a house. Okay, your estate plan is your house. These estate planning tools are just that. They're the wrench, they're the hammer, they are the screws, they are the components that you need to put your house together. And depending on the type of house that you build, and I don't want to go too deep, one of my daughters wants to be an architect, and she's very interested in building and construction. It's very fascinating. So I kind of study when she's looking at things. And so depending on the type of house you want to build, there are different materials. If you're building an eco-friendly electric house, it's very different than building a house, even geographically. Your tools will be different depending on the type of house that you want to build. And so I say that to say, you may or may not need all of these things. You may or may not. It just really depends. And I cannot harp enough on the fact that the grass is not green on the other side. You cannot look at someone else and what they're doing and compare it to you. Your estate plan has to be organized specific to you, your life circumstance, your communities, and the tools that you have ready at your disposal. Okay, so just a quick overview. Again, I am very big on vocabulary. I've been practicing law for 15 years and adjuncting with another University of Maryland school, University of Maryland Global Campus, and a community college here in Maryland for 13 years. Okay. And so I'm very big on the vocabulary because that makes it easier to understand these things. So intestate. It's a term that we do not use in our everyday lives, but it's a term that you actually need to know. Intestate is the legal status by which someone dies without having a will in place. So if you pass away without a will, your status is called intestate. If you have a will, your status is testate, okay? Advanced medical directive. Advanced medical directive consists of two different parts. And the reason why I'm giving you this language, I know that most of you, based on the chat, are based in Maryland. However, some of you do reside in other states. And some of you may be here now and may move. The language that we are using, it is different from state to state. And so I want you to be very careful, and I want to give you information so that you understand the theory and you can attach the appropriate language. And so since I'm on this point, I also want to say this. Estate planning is a jurisdiction-specific legal process, just as estate administration, which is probate or trust administration. It is governed typically outside of trust. It is governed by the state of your primary residence or domicile. And so if you are a Maryland resident, I am so sorry. I thought my phone was off. I apologize about that for the recording. If you are a Maryland resident, your domicile is Maryland, and therefore that is the estates and trust law that will govern what happens with your estate. Okay. And the reason why I want to go back to the language again is because different states use different terms for different things, and I don't want you to be confused. So advanced medical directive, it's composed of two things, two parts. There is a healthcare proxy and there is a living will, and it's already getting confusing, I know. The healthcare proxy allows you to name a healthcare agent for yourself in the event of a disability that causes incapacitation. It's simply you giving authority, you the principal giving authority to an agent. The living will is the second part. It is you giving specific directions about your treatment to your agent as well as your medical professionals, so they're not in the dark. And we'll discuss that in a little bit more detail, but it's two-part. Healthcare proxy, which can also be known as a durable healthcare power of attorney. So if you are in a different state, it may also be called a durable healthcare power of attorney. That's the healthcare proxy where you are giving authorization to another person to make medical decisions for you. The living will is where you are giving instructions about the care that you want. It is very different from a last will and testament, okay? Those two components together make your advanced medical directive. A durable power of attorney is typically a document that I will also say this, powers of attorney are not exclusive to estate planning, but they're used as a tool in estate planning because it's a document where you can appoint an agent to make financial decisions for you. So advanced medical directives is healthcare, durable power of attorney is financial decisions. Your last will and testament is what most of us know as the will. We're learning this during Wills Week. And it is just that. It is your last set of instructions to your loved ones, to your community, and to the state, really, as to what you would like to happen that you're no longer here. It is more than just, you should use it for more than just saying what items you want to go to which beneficiaries. And we'll talk about that a little bit more. Revocable trust. And those letters, Q-tip, charitable lead trust, charitable remainder trust is what those letters stand for. Revocable trusts are, let me take a step back. A trust is you essentially put in items in a bucket. The trust is the bucket. The items are your assets. You put your assets in the bucket that we'll call a trust for specific reasons. And we'll talk about some of those reasons: avoiding creditors, protecting minors, protecting adults with disabilities, supporting your charity. There are many reasons why you would put items in a bucket to put them in trust. But when you put them in a bucket, you create a distance between yourself and the trust, where you're no longer the owner, but you put them in a bucket for that bucket to be its own entity, to really own and have possession of those assets. When you have a revocable trust, you're putting them in the bucket, but reserving the right to take them out of the bucket. Okay. And that's essentially what that is. When you have an irrevocable trust, or irrevocable, some people put tomato. When you have an irrevocable trust, you are putting them in the bucket, and you're really limiting the situations in which you yourself can take your own assets out of that bucket. And there are some great reasons to do that, okay? But there are some reasons why you may not want to do that as well. Again, I'll come back to it. You have to find what works for you. Discretionary needs trusts and special needs trusts, these are trusts still doing the same things, but they're created for a particular purpose. And we'll talk about that a little bit more. So planning, organizing your plan is what we're going through. And I really want to break this up in two parts. There's planning for disability, and then there's planning for the transfer of wealth. Okay, so planning for disability is your advanced medical directives and your powers of attorney. And the reason why these two tools are used to plan for disability is because they're only effective while you are living. While your heart is beating, you have life in your body, they are effective. The moment you die, they die with you. And so they are really tools that you use in the event that you are living yet incapacitated. And I want you to really think broadly about incapacitation. A lot of people think, old age, dementia, yes, those, and Alzheimer's, yes, those are versions of in which people can be incapacitated. However, I will challenge you to think differently, because I had to think differently. I've been in solo practice for 8 years now. My youngest daughter is 6. There was a period of incapacity that I sustained when I went through the process of childbirth. I am a business owner. I had clients. I am a member of my family. I am the one who, manages everything in a house. I make sure all of the bills get paid, all of that. My husband goes to work. We have defined roles in my house about who does what, right? And so I am typically the decision maker, not only in my home, but also in my business. The natural life process of childbirth created a period of incapacity in which I really had to plan around that. At the time, I knew I needed to plan, but I didn't really understand, because actually having my last daughter was one of the hardest post-recovery processes that I had. And while I was capacitated at that point, I needed someone else to step in. I really, really needed help. And so I want you to really think about periods of incapacitation that are not what we typically, a lot of lawyers give the Terri Schiavo example. If you remember Terri Schiavo in the early 2000s, where she was a young woman. I don't remember why she suffered from incapacity, but she was incapacitated and newly married. And we'll talk about the consequence of newly married and not having a will, or not having, because all marriage is not created equal, depending on your jurisdiction. So she was newly married, and there was a difference in decision from her husband and her parents as to whether or not she should be kept on life life support, and life support was the only thing. It was life support and food via G-tube, via G-tube. Those were the only things really sustaining her life. And it went all the way up to the Supreme Court. And the result of that is the court ended up deciding in favor of her husband, terminated the life support. And one of the pushes from that was that everyone should really draft their own medical directives, because the court doesn't want to be involved in these decisions. And so that's a classic example, but that's also an example that a lot of us exclude ourselves from because it is so extreme, right? But the process of childbirth, should you decide to go through that process, is something that can cause incapacity. I know it did for me. Another thing that that it seems a minor, but I had to have several teeth extracted. And again, it came up again that I had to actually utilize these documents, having power of attorney to a business associate to step into my business endeavors, and having an advanced medical directive for my spouse to really come in and make moves quickly. So when we think about disability, I really want you to think outside of old age, okay? Planning for the transfer of wealth, last will and testaments and trusts are tools that plan for the succession of wealth. And then business succession planning. This is one that, again, that's dear to my heart because I am a business owner. Some of you may have entrepreneurial endeavors. I don't care if you sell items on Etsy or you bake cakes for, the neighborhood team and everyone buys them. If you're making an income that you have to file on your taxes, you are a business owner, in my opinion. And so you need to make sure that you're planning for the transfer of that. So advanced medical directives, a lot of these slides I'm now going to go through quicker because I did do a lot of explaining of these things. 2 basic objectives: to appoint a healthcare agent, to state your treatment preferences. Okay, your healthcare agent is someone that will be allowed access to your medical records. Everyone knows or should know about HIPAA, which is H stands for health, the P stands for privacy, one of the A stands for acts. I can't remember the definition, but basically it protects your privacy in healthcare. And because you have a federally protected healthcare right, your hospital is not, or your doctor is not and should not just give your medical information to anyone. So your healthcare agent is the one that you are authorizing in advance to receive your medical information. For those of you who have children who are turning 18, for some of you who may be on here that are 18, I'm not sure of the characteristics of everyone who's listening. Let me tell you this, again, from personal experience. The reason why you see younger people, at least my anecdotal thoughts about why you see younger people estate planning, is because you have younger people who have gone through more traumatic events in their development than an older group. Myself, perfect example. I'm a millennial. Y2K was the first scare. Why we got over Y2K, we then went into college, and 9/11 happened my freshman year of college. I am from New York. It was traumatic and devastating. Didn't even realize how traumatic until years later. Graduate out of college, get into law school. First year of law school is Hurricane Katrina, affected a lot of individuals that I knew. Get out of law school, and guess what we're in? A full-blown recession and a market crisis, a real estate crisis. And we get through that, and long and behold, we're in a pandemic. And let's not even discuss the whole student debt issue, okay? So you see younger people planning, because I think there is at least when I speak again, anecdotal amongst my peers, tomorrow is not promised. And so we understand this, and 18-year-olds, particularly if you're a parent, when you send your kid off or your young adult off, they don't have a clue about just how dangerous the world can be. No one thinks anything happens to young people. However, if you send your 18-year-old off to school and there's a medical emergency, what happens? what happens? Do you have the authority to contact those medical institutions to get information and to make decisions for them? Because at 18, they are adults. And I experienced this myself in college. My freshman year of college, I had just turned 18 and I got gravely ill. I'm from New York. I went to college in Pennsylvania. I am my mother's only child. So you already can think about the dynamics of this. We didn't have a plan in place for this, and the hospital would not give her any information. I thank goodness for some individuals at my college, and quite frankly, some people at the hospital who were willing to break a little bit of the rules at that time, because HIPAA had just come out. Or not just come out, it was just being put into practice a little bit more, and it was a lot. And so I would encourage you, if you have an 18-year-old, the Advanced Medical Directive is on a Maryland Attorney General's website. It needs to be filled out, signed by 2 witnesses who is not an agent or the principal given authority. Just have it because you just never know what's going to happen. Treatment preferences, the second part, the living will, permits treatment preferences. And so there are typically 3 different medical stages that are considered. And I'm sure there are medical professionals on here. If we were in person, I would have you jump in the conversation. But these are 3 different types of medical conditions where there may be incapacity, where your treatment preferences, how you would want your medical professionals to engage you and your family to engage you may be different. And so one is when death from a terminal condition is imminent despite the implication of life-sustaining procedures. So this could be anything from, a surgery that didn't go as planned, having a heart attack, a car accident, with internal bleeding. There's nothing that the medical professionals can do to preserve your life. Death is going to be imminent. How would you like to be treated? Would you want a feeding tube? Would you want catheter care? Would you want pain medication is a given. You can't opt out. You're going to receive pain medication according to the Attorney General's advanced directive. But what type of care do you want? When your condition of a permanent unconsciousness is persistent, it's called a vegetative state. This goes back to the Terry Schiavo example. Then there's an end-stage condition that advances, is progressive, and is incurable and will eventually result in complete physical dependency. This could be anything from dementia, Alzheimer's, to a stage 4 cancer. And I say this, I like doing these sessions because, again, I do them from a very personal place. I've had to walk with a grandparent. My father-in-law is deceased. He passed away December 2001. We had to walk through some of this. My current paternal grandmother suffers from dementia in New York. So a lot of these things I've had to walk my family through. So I understand how difficult it is to really make some of these decisions, hence the reasons why I developed the Difficult Discussions Guide, because if you never had to do it, you don't fully understand until you have to do it. But unfortunately, when you have to do it, it's a little too late to plan. So I want you to kind of think about a lot of these things in advance. Long-term care, I will not harp on because there's another session about this, but I will mention that long-term care should be a part of your estate planning, your comprehensive plan. What is the likelihood of you needing long-term care in the future? Is highly likely for all of us, given advances in medicine and how well we're beginning to take care of ourselves. We're in a society that is moving towards exercise and healthy living. We're living longer. So what does it look like to age and to live? What support do you have and how will you fund it? And so I just want to put a plug there and leave that for the one of the later sessions. And so we'll go into our next tool, again, a power of attorney. I know there's something going on in the chat. I think we're reserving all the questions to the end, so I'll keep going, but please make sure you put your questions in the chat so that we can come back to them. Powers of attorney, I mentioned that you are given authority to an agent. It is a financial tool. And so vocabulary, again, you are the principal, the person given authority. The agent is the person receiving authority, okay? The one thing that I want you to understand is that this is a fiduciary duty, meaning they have a legal obligation to function on your behalf and in your best interest, or shall I say the agent has a legal obligation and fiduciary duty to function in the best interest of the principal, okay? And so just know that. I know a lot of people are fearful of giving someone authority, but there is a legal obligation and there's great weight to it. So there are different types of powers of attorneys. Again, I mentioned that we use it as an estate planning tool, but it's not exclusive to estate planning. And so I categorize them in 3 categories: limited versus general, springing versus immediately effective, durable versus effective only during the principal's capacity. You definitely want a durable power of attorney. We'll talk about whether or not you want it limited, general, springing, or effective immediately. So a general power of attorney is a very broad authority that you're giving to the agent. I'll also say this: effective October 1, we actually have a new statutory general power of attorney. So this is, if you haven't done one, this is kind of a good time to really learn. And again, this is available on the Maryland Attorney General's website. And so I would encourage you to read it for sport. I know it sounds like a very nerdy thing to do. Let me give you an example. I had a friend who was over. He took a job in one state. He took a job in Massachusetts. His family lives in Delaware, and because the kids are in school, the family's not moving to Massachusetts into the summer. All of the cars are in his name, and one of the cars that the son drives needs to be registered with the state. And so he happened to be visiting for something with my husband, and he said, I'm a notary. So he said, can you notarize this power of attorney to do the vehicle transfer? I said, yes. So I explained to him what it is. And then I said, well, why don't you just give your wife general power of attorney? He said, absolutely not. I cannot give her that much authority over me. And it led into a lively conversation. And so the reason why I mention that example is because I want you to really read it before there is the need for it, so that you can have the conversations up front. Because we sat in my living room and talked for 3 hours as to why he would not give his wife of 20 years general power of attorney. Because I was just baffled, but I understood. Okay, so general is just a broad authority. Limited power of attorney is giving a limited authority. So for example, if I have a sister-in-law that lives in Florida, my husband and I are consistently talking about purchasing a vacation home. I don't have the time to go to Florida, but I trust my sister-in-law. I can give her a limited power of attorney to purchase a home for me in Florida and to act on my behalf at closing. If you purchase the home, you may give limited power of attorney to a settlement agent or something. And so limited power of attorney, again, is not just used, these things are not just used for estate planning, they can be used generally. Springing versus immediately effective. Springing means just that think about springing off, diving board into the swimming pool. Springing means that it comes into effect upon some condition. Usually that condition is incapacity. Immediately effective means just that is immediately effective, that having capacity or not, your agent can go out and act on your behalf. A lot of people are uncomfortable with that immediately effective power of attorney. A lot of people want the springing power of attorney, where the agent will have to certify incapacity with letters and recommendations, certifications from 2 medical professionals who are treating you at the time. Here is my thoughts on that. These are just my thoughts. These are not the thoughts of the University of Maryland school system at all, just me. If you are concerned about what your agent will do in your presence when you have capacity, you probably should not make that person your agent in the event that you are incapacitated. I understand why a springing power of attorney exists, and I also understand how it's used. As a practical measure, if I can't trust you with my eyes on you and the ability to correct you, why would I trust you if I'm not able to correct you? It's just me, just my thought, but something for you to think about. Durable versus conventional. This is a biggie, okay? This is a biggie for all of my legal Zoomers, from all of my Googlers who download documents, okay? This is a big one. Traditional or conventional powers of attorney, again, you, the principal, are given authority to an agent. And so the idea is if you don't have capacity to give authority, the agent doesn't have capacity, you can't empower an agent to be in authority. So with a conventional power of attorney, disability terminates the power of attorney, the authority of the agent. If you want your power of attorney to be an estate planning tool by which your agent can still pay your bills, access your funds, and keep the party going in the event of disability, that power of attorney has to be durable. The good part is the state of Maryland presumes that your power of attorney is durable. So if it's silent about if your power of attorney is silent about whether or not it's durable or conventional, the state of Maryland will assume that it's durable. I cannot tell you how many children of elderly parents come to my office, or siblings of elderly siblings, and it's, I don't know why this is what it is for my office, come to my office saying that they need to transfer real estate, do something with real estate. That's typically why they're coming to me, real estate or business interests. And they say, I found you, online, in a magazine, wherever. I have power of attorney over X. And I say, okay, great. Let's go through the intake process, which includes you giving me a copy of the power of attorney. I want to see a copy, but also I want to see the original because I'm a stickler for that. And they upload a copy or they provide a copy of it. And immediately I can tell that it's not a durable power of attorney, meaning it says this power of attorney is not meant to be durable. And I say to myself that had to be an accident. That had to be a lack of understanding. There's no way, or maybe the principal did, want to only give a conventional power of attorney and did not plan at all for disability. Nonetheless, I see it far too often where individuals have the wrong type of power of attorney. So I will say it again, if you're not seeking professional help, utilize the Maryland Attorney General's website to make sure that you are utilizing the proper form. And at the end of this presentation, I'll jump to it now, you also have to make sure that the document is executed to have the proper legal effect, which means that for powers of attorney specifically, because of the financial interest that's being transferred, it needs to be witnessed by two disinterested persons, and it needs to be notarized. So the notary, and there is a lot of confusion even amongst the legal community, and COVID brought out just how complex this matter was when we weren't able to all be in the same office. What happens when you have to have the principal sign in the presence of two witnesses and a notary, but all of these people can't physically be together? This was a really big issue during COVID. And nonetheless, I want you to understand that it's not just about pulling these documents off the website, but making sure that you execute them in a manner in which they're going to be legally sufficient and effective. Planning for wealth transfer. And if someone can tell me how much time that I have not been paying attention to the time. Let me know when I have to wrap up because I don't remember, I apologize. But planning for the transfer of wealth.
Hey, Shari, you have about 5 minutes left, and then John will hop on for Q&A.
Perfect. I knew I was going long. Perfect. So here's what I want to tell you about planning for why are you planning? You want to, for those of you who have higher wealth, you want to make sure that you avoid federal and estate tax. Okay. You can see right now it's very high. You can read the numbers on the screen. State of Maryland, you will be taxing your estate at the rate of for estate tax if you have 5 million for an individual, 10 million for a couple. Okay, and so you just want to make sure you plan around that. Also, inheritance tax is big within the state of Maryland. You will be taxed if you are giving property to anyone other than a lineal descendant, parent, child, spouse of a child. Okay, there is a 10% inheritance tax on the property transfer. Last will and testament, a lot of this I already covered as to what it does. Here is what I do want to harp on: intestacy laws. A lot of people think that a lot of people are wrong as to how property will transfer. If you're married with children, the property is split between your spouse and children. I can tell you right now that most people don't like the split. If you're married without children, the property can be split between your spouse and your living parents, depending on how long you've been married, meaning all length of marriage, all marriages aren't created equal under intestacy. Unmarried with children, children will inherit everything. Unmarried without children, your living parents will inherit everything. If your parents aren't living, the issue or the children of your parents will inherit. We call them siblings. The reason why I say children of parents is because I find that there are children of your parents that you may not know about that may be entitled to your estate if you pass away intestate. And then if there are no siblings, your property is sheets to the estate. Adoptive children are treated like biological children. Foster children and stepchildren do not receive anything automatically, so you have to plan. All property does not pass through your will. So that's another point of estate planning that you will need to talk about. Here are some provisions that are necessary to put in your will. The one I want to cover the most when we're talking about organizing your plan: who will be the guardian for your minor children if you have children? If you have no dollars, but you have minor children, you need a will because you need to designate a guardian. And who will that person be? And will they play nice with family members? So it really requires you that you sit down and organize. What is your family structure? How does it really work? And who will be put in charge? And the first person that comes to mind, is that the best person to put in charge of your children and of the money that will follow your children? I already talked about legal effect of your will, and make sure we are executing not only your will, not only your power of attorney, but executing your will in the proper form. You will have another session that talks about what actually happens upon your death, but I did want to touch on trust a little bit. And so essentially, if you fall into any of these categories, you want to avoid probate, you want to protect your assets from creditors or protect from the benefit to your beneficiaries. Maybe your beneficiaries have creditors, you want to do a trust. If you have a child with special needs that may be an adult with long-term care needs, you want to make sure you plan for that, because there is some governmental entitlements that they may be entitled to that they would be able to receive if they don't have ownership of that property directly. And also, for those of you who are into tax planning, there is some great reasons to have a trust for tax planning. And so again, this is just the very basic of some of the things that I wanted to show you, but I'll go down to this covers business succession. I want to go down to your checklist. What do you need to begin estate planning? Take inventory. Who do you have? Who's a part of your community? Who helps you day to day? If you get the flu, who's bringing you soup? If you have to go to the hospital, who's coming to visit you? Who do you take care of? Who takes care of you? What community groups are you a part of? Write them down on a piece of paper. A lot of us assume a lot of things. Put it on a piece of paper, just a plain sheet of paper. What do you have? Your financial advisor may be able to help with this if you have one. If you don't have a financial advisor, you probably need to get one. But what do you have? What do you plan to transfer? This is wealth, but this is also sentimental things. This morning I thought about my broom. I jumped the broom when I was married. It is a tradition in typically in African American culture, because there was a time where we were not able to legally marry, and so to validate or cement our marriage, we would jump the broom. And so it's something that happens in my family. It's a part of my culture, and so I have a broom. It's very important to me. I have 3 daughters. You see where I'm going here. That is something that I would include in the what do I have. It's a sentimental artifact for my family that everyone who has gotten married has jumped. Has no real value financially, but it's significant nonetheless. And so I need to make sure I plan for the transfer of it so my daughters don't fight. Okay. Assess your inventory. Why do you have them? This really goes to those who are philanthropically inclined, because if you do want to be a charitable, you want to make sure that you have the most impact. So understand why you have them. This requires a lot of self-reflection, a lot of just talk and thought, and being clear on the legacy that you want to leave. What impact do you intend to have on your family, the community, and the world? I can tell you right now, I don't want my name on the building, but my grandfather's name will be. That is the impact that I want to have. My grandfather was a sharecropper who managed to jump a million hurdles so that his legacy would be cemented within me. And so that is something that's a part of my legacy that I want to do. I want to build in with his name on it. And so my kids need to know that. And so then you want to incorporate the proper estate planning tools to meet the goals that you want to reach. Thank you all for having me. I'll shoot to John for questions now.
First question is, what happens if you live in Maryland and establish a will and trust, and after a few years you move to another state? Does one need to redo their whole estate, will, trust, etc.?
So a couple of things. So short answer is no. Your will should be effective in another jurisdiction so long as it was executed in a way that is accepted by that jurisdiction. So for example, you may have the state of Delaware, this is who only requires one witness and a notary. There is a legal question as to whether or not Maryland will accept that will, because Maryland for a long time has required 2 witnesses and a notary. So we would have to look at when that will was executed, what was the law in Maryland at that time to make that determination. So it does get a little complicated in that. So that's the answer for the will, but generally, yes, another state should accept it. For a trust does not have to be created in the jurisdiction of your residence. A trust jurisdiction we call a situs, and that is basically any jurisdiction that you want, so long as you can find a trustee in that jurisdiction to serve, or excuse me, a resident agent in that jurisdiction to serve. And so it's that question is a little bit more complicated than it seems on the surface, but it generally, yes, it should be accepted. But if you are moving and you're moving permanently, I would encourage you to take your will from your prior estate to an estate planning attorney in your new state to have them review it.
Okay, great. Next question is, I'm in the age group where a lot of my friends who are single are needing someone to be power of attorney and are asking me if I will serve that role. What cautions should I keep in mind before I say yes? Are there limits to the number of people I should say yes to?
Ooh, okay. Same. I have the same experience. I think you should, we can't foresee all that will happen in a person's life. And so I think you should really have deeper conversations with all of those individuals and not take on many. Because what happens if two individuals are ill and unable to function on their own at the same time? That's a lot. That's a lot of pressure. I use the term caregiving because it's the same responsibility for children, parents, or friends. It doesn't matter. So, two friends is equivalent to having two kids or taking care of two parents. That's a lot of pressure. So I personally would say, no, do one, but have conversations with them about expectations. The reality is that a lot of us don't have many people that we trust. And it sounds like you are a very trustworthy person, which is why everyone's coming to you. But you may have to politely decline because it does sound like a lot of work. Not to mention, I didn't even get into responsibilities where that if you are power of attorney for a significant amount of time, and some power of attorneys allow for the appointment of guardian, where you could become, there is now a financial reporting component associated with that. And it's work, it's a job, which is why on one of the slides you can be compensated for it. So it is another job though, and I don't think that you should take it lightly in thinking about it.
Okay. Next question. Do you know if DC has AG docs available?
I do not, unfortunately.
Can you clarify what AG docs?
I believe that person is referring to the Attorney General document. So I mentioned
Okay.
the Maryland Attorney General's website for the power of attorney and for the advanced medical directive. I do not know. I don't practice in DC, so I don't even look at it. Sorry.
Okay, next question is someone was having their office vacuumed when you made your statement regarding children who come into plan for their elderly parents and elderly siblings. If you could repeat that statement, that would be great, as I plan on assisting my 74-year-old mom in her will and estate planning.
I have no idea about the exact statement that I made, but I have no idea. This is recorded.
Good news is that we have a recording, so this person can go back and review that part of the recording. Okay, making trust for land to be developed. Will the trust need to be changed after the house is built?
No. So if your trust should be written with your goals in mind. And so if you are developing a trust with the intention of developing land and you're deeding the land into the trust, I don't see why you would. That would be a part of your drafting and the planning. And of the home being built on the land is infrastructure on the land. And so, I don't see why it would. But here's another key fact. A trust is a written agreement. That's all it is. It's a written agreement that's executed that's then funded by assets. And so for my nursing people, where they say if it's not documented, it's not done. So you need to make sure that writing is in there, or at least there is general authority for what you want to happen. I don't want to assume that what you want to happen will happen. You need to read it and make sure that your trust document gives the authority for that.
Okay. Are stepchildren included when splitting between spouse and children?
Are stepchildren included? Let me say this because
they're probably asking about the statutory requirements.
Yeah. So let me say this. If person A is step parent to person B's children, person's A's assets under intestacy laws does not directly pass to person B's children. So if person A desires to support and benefit person B's children, and I'm saying this instead of stepchildren because sometimes it can be confusing, then person A needs to draft something to create the provision for person B's children. I hope that's as clear as possible.
Okay, good. All right, just a few more. We have a 15-minute, the next presentation starts at 1:15, but let's just answer a few more questions if we can, and then shorten our break to 10 minutes. Okay. Twin children, can you make co-executors of your estate?
Yes, it doesn't have to be twin children. So in Maryland, we don't use the term executor, we use the term personal representative, but it's still the same function. You can have co-personal representatives, you can have co-trustees if you have a trust. Again, you can do a lot of things. The question is it prudent to do it? Because when you are making co-executors, do they have to make decisions together, meaning there has to be agreement, or can both of them do whatever they want and it's the wild, wild west? I would ask why. So if you were coming to me, I would ask, why do you want to do that? Is it because you don't want to make one child feel a way about another one? That's a conversation we need to have, because the reality is some kids are more responsible than others. I can tell you right now, my middle daughter is going to be the one that takes care of me physically. We just had that conversation, whereas my older daughter is the one who's going to control the finance. And we have to be clear about that. I know that at 15 and 13. So I would ask why, more so why you want to name anything, but yes you can, but be clear on what that may look like in administration, because that's the part that I do and I see it gets really, really messy. So my advice comes from doing a lot of the administration on the back end and realizing that a lot of these things don't work.
Okay, and then very last question, because it's from anonymous. Everyone else, I've got your names, so I can give Shari your questions and hopefully you can get an email from her afterwards. But anonymous asks, can children waive the interest? And if they do the portion have to be given to the Board of Education?
Can
Not sure.
children waive their interest? Okay, so first off, children can't do anything. Minors can't do anything. It's really the guardians or the parent of the minor who's making the decision on behalf of the minor. So can they waive their inheritance? Sure. Again, sure. You can waive, the parent or guardian on behalf of that minor can waive their interest. Again, I would more so want to ask about the why. Why are we doing certain things, to be able, and this is a really difficult question because I'm not really clear on what's being asked,
Yeah,
but I would again focus on the why. But can a parent or a guardian waive a child's inheritance? It's called disclaiming. Sure. But why would we do that?
Right, yeah. That's unfortunately all the time we have for questions for this session. We'll take a 10-minute break to stay on schedule, and the next session will start promptly at 10:45. Thank you very much, Shari. We've gotten a lot of positive feedback in the session. I know some folks here want your contact information, which we will provide as a follow-up, but thank you again. We really appreciate sharing your knowledge with us this morning.
Thank you for having me. It's been a pleasure, and I hope to hear from some of you.
Okay, we'll return at 10:45 sharp. Thank you, everyone.
Bye-bye.